A new legal blow to President Trump's immigration crackdown. A federal appeals court says he unlawfully invoked the Alien Enemies Act to quickly deport alleged Venezuelan gang members. The Fifth U.S. Circuit Court of Appeals ruled that the administration cannot move forward with using the centuries-old wartime law for deportations in Texas, Louisiana, and Mississippi. In a 2-1 decision, the judges rejected President Trump's claim of an invasion or predatory incursion by the gang Tren de Aragua. The case is widely expected to end up before the Supreme Court. We have CNN senior legal analyst Ellie Honig here with us on this. All right, Ellie, first off, why did the court 2-1 say that there was no predatory incursion by the Venezuela gang Tren de Aragua, as Trump had claimed?
Well, because those terms simply do not apply to the situation here in the court's ruling. Now, Brianna, this is a historic ruling. This is the first time a federal court of appeals has ever reversed a president's invocation of that Alien Enemies Act. Now, it's only been invoked a handful of times in our history, most recently before this World War II, but this is a first. Now, as you said, the law empowers the president to deport non-citizens if they are part of an invasion or a predatory incursion carried out by a foreign nation or government. And in this decision today, the court goes through those terms and said there needs to be some element of organization. You can't just say, well, we have large numbers of immigrants or emigrants coming to this country. That's not enough. And there's not enough of a tie that any of this comes from a foreign state or a foreign government. So simply put, the court just looked at the terms of the law and said they do not properly apply to the actual situation here.
So what's the effect of this ruling? What are the limitations of this ruling?
So for now, it means that at least in the Fifth Circuit, there cannot be deportations under the cited Alien Enemies Act. But I think, Brianna, this one is absolutely headed back to the Supreme Court. Now, it did make a detour at the Supreme Court earlier in the spring, and the Supreme Court did not rule on whether the Alien Enemies Act applies. They simply said that people who are going to be deported under this law, they do get some minimal due process rights. And in the process of exercising those due process rights, that's how we got to this decision. So the Fifth Circuit is one of 13 circuits, federal circuits in this country. And typically, once a case has gone up to the Court of Appeals, the circuits, the next step here is likely going to be the U.S. Supreme Court. And I think it's a case the Supreme Court has been expecting to come back to it and really almost has to take, because we can't have a situation where you have potentially different outcomes in the different circuits.
So to the layperson, they might look at that and say, wait, why did they get this, as an emergency matter, kick it back down, only to ultimately get it again? It seems like a bunch of back and forth when ultimately the Supreme Court is going to have to decide on this.
It's a perfectly reasonable response and one that I shared. Why not just decide it? Instead, they do what they do sometimes on the Supreme Court. They decided it on a very narrow basis. They basically just said, for now, these deportations can proceed. However, lower courts, you have to make sure that people are getting due process. It was all but a certainty that we would come back to this point, that in the process of that due process, someone would challenge the Alien Enemies Act. And now we have our first Court of Appeals saying that the way the president has used it is unconstitutional.
I also want to ask you about this appeal from the president and Defense Secretary Pete Hegseth of a California federal judge's ruling yesterday that they violated the Posse Comitatus Act by using U.S. military for domestic law enforcement in Los Angeles this summer. What are you watching for here?
Yeah, good use of Latin, Brianna. So I want to see whether Judge Breyer gets reversed again. Let's remember, this is part two. Back in part one, Judge Breyer said that Donald Trump, as president, does not have any authority to send the National Guard into California, and then he got reversed. That's why the National Guard is in California. Now Judge Breyer has come back with a narrow ruling saying basically, well, the way that the National Guardsmen are being used violates that Posse Comitatus Act, basically the idea that your military cannot perform civilian law enforcement functions. He went through the record and said there are several examples of them crossing that line. So now the Trump administration is appealing that one as well. I don't know that he's likely to get overturned on this one because it's a much narrower ruling and I think much more in the judge's discretion. But we'll see. He got reversed once, and we'll see if the Ninth Circuit is with him or against him the second time through.
You say comitatus, I say comitatus, which means that you're right, because most of the Latin that I use is in our segments, in fairness. Ellie Honig, thank you so much. Really appreciate it.
I didn't say when, but the answer is, look, Chicago's very interesting because I watched Pritzker get up and say we don't need help, we're safe. But 2 weeks ago, they had 6 people murdered, and they had 24 people hit by bullets. Well, we're going in. I didn't say when, we're going in. When you lose, look, I have an obligation. This isn't a political thing. I have an obligation.
Welcome back to Way Too Early. It's just before 5:30 here on the East Coast, 2:30 out west. I'm Ali Vitale. And that, of course, was President Trump doubling down on his plan to send National Guard troops to Chicago. In response, Democratic Governor J.B. Pritzker of Illinois called Trump unhinged and said federal intervention was neither needed nor wanted.
I want to address the president's unhinged remarks a few minutes ago, begging me to call him. No, I will not call the president, asking him to send troops to Chicago. I've made that clear already. I'm aware that the president of the United States likes to go on television and beg me to call and ask him for troops. I find this extraordinarily strange, as Chicago does not want troops on our streets. I also have experience asking the president for assistance, just to have the rug pulled out from underneath me when execution meets reality. I refuse to play a reality game show with Donald Trump again.
But then listen closely to hear to what Chicago Mayor Brandon Johnson is saying, because he's criticizing Trump for failing to focus on illegal gun trafficking in Chicago.
We need the federal government to stop the endless flow of guns into our state and into our city. The vast majority of guns do not come from Chicago. They are not made in Cook County. They are not bought in the state of Illinois. These guns come from red states. They are coming from Indiana. They are coming from Mississippi. They are coming from Louisiana. And that is the harsh reality, whether Republicans like it or not. Occupying our city will do nothing to solve this problem.
This president doesn't care about gun violence. He just wants his own secret police force that will do publicity stunts whenever his poll numbers are sinking, whenever his jobs report shows a stagnating economy, whenever he needs another distraction from his failures. That's what this is about.
It's important to underscore what you're hearing there from top officials in Illinois and Chicago specifically. They're not saying there's no role the federal government can play here that won't help us. They're saying there are things you can focus on, gun violence prevention specifically. But what they're saying specifically, too, is there is no role for troops here that will make the situation on the ground better. There's a difference. Meanwhile, in California, a federal judge ruled President Trump violated federal law when he deployed the National Guard to Los Angeles early this year. In June, the Trump administration sent 4,000 National Guard troops and 700 Marines to the city after thousands of people took to the streets in protest of the president's immigration policies. Now, a U.S. district judge says the deployment breached an 1878 law that prohibits the president from using the military as a domestic police force without congressional approval. California officials had argued the use of the National Guard created fear and disrupted civilian life. Lawyers for the Justice Department claimed the troops were just protecting federal property and personnel. Joining us now, former litigator and MSNBC legal correspondent Lisa Rubin. Lisa, this L.A. ruling is likely to factor into whatever happens on the ground with Chicago now, because Pritzker is doing exactly what Newsom did in California, saying we don't want troops here. And Trump is saying, I'm going to do it anyway over your objections. Talk about how the legal plays with the political now here.
Well, you know, Ellie, it's interesting because looking at it politically, you can't help but see the similarities between the two situations. And yet, legally, what this court has decided in San Francisco does not formally impact the Trump administration's ability to do so in Chicago, and will not formally prevent them from doing so unless and until the Supreme Court rules. So I would expect the Trump administration to continue pushing the envelope in Chicago and continue down the same path that President Trump promised. Why? Because what this judge says in San Francisco, even if upheld by a federal court of appeals, will not have an actual legal effect on what the law is in Chicago, what the law is in Illinois. Those are two separate federal appeals courts. And in fact, what the Trump administration might be hoping for is what we call a circuit split, where two federal appeals courts decide differently, and then you have no choice but to get the Supreme Court involved. They're going to try and do this in as many different places as they can until and unless they are blocked by courts with actual jurisdiction in the places where they're doing it.
So because of that legal backdrop that you just so skillfully set up, how should governors respond to the administration's efforts to send troops to their cities? We watched the way that Newsom did it and the resulting court battle there. What could Pritzker do here to set up a court battle that's similar but different and kind of gets to the same end of potentially trying to limit Trump's ability to send troops here?
Well, Pritzker, as well as the Attorney General for Illinois, would be well served, I think, to start a similar lawsuit in Chicago federal courts, trying to enjoin the use of military for immigration-related enforcement on the same basis that Governor Newsom and Attorney General Rob Bonta were so successful in doing in California. And there, they don't just have a preliminary injunction, they now have a permanent injunction that means that President Trump cannot use troops even to protect federal property or personnel with respect to immigration enforcement until a federal appeals court says essentially that that's okay. Now, that ruling doesn't take effect until September 12th to give the Trump administration an opportunity to go to an appeals court and seek a stay. But if I were Governor Pritzker and his attorney general, what I would do is look to Newsom and Bonta and try and imitate that same lawsuit in the federal courts in front of me in Chicago and also then in the Seventh Circuit, which oversees Illinois.
So, Lisa, that was a key ruling that broke late yesterday, but it was far from the only one. It's lucky that we have you on a morning like this, because overnight, a federal appeals court ruled against President Trump's use of the Alien Enemies Act of 1798. He used it to rapidly deport Venezuelan migrants that he alleges are suspected gang members. Earlier this year, Trump issued a proclamation to invoke the act to fast-track the deportations process. The president saying it was necessary in cases concerning Venezuelans suspected of being gang members because of his words, mass illegal migration. The Fifth U.S. Circuit Court of Appeals said in its ruling it would grant a preliminary injunction to prevent removal because we find no invasion or predatory incursion had occurred. But Lisa, are there any other legal maneuvers here that the administration might make to circumvent this latest deportation ruling?
Absolutely, Allie, because this ruling only applies to the Alien Enemies Act. What it says is that they can't use the AEA to deport alleged members of Tren de Aragua from Texas to Venezuela. But that doesn't mean that other legal authorities and other immigration statutes aren't available to them. The other thing that I would point out to people looking at this is that the dissent here is as important as that two-judge majority opinion. The reason why is it's written by a guy named Andrew Oldham. Expect to hear that name a lot more in the months to come. Judge Oldham is expected to be among the frontrunners for any Supreme Court seat that President Trump has to fill, and his dissent, which he says represents the first time in the 227 years of the nation's history that a president has been blocked from using the AEA in very strong terms, reads to me more like an audition than a legal opinion.
It's really important context that you bring in there. MSNBC legal correspondent Lisa Rubin, thank you as always.
A blow to President Trump's immigration crackdown. A federal appeals court now says that he illegally used the Alien Enemies Act to quickly deport alleged Venezuelan gang members from the United States. The court rejects his claim that the migrants were part of a quote-unquote invasion. It was in March, you'll remember, that the president invoked this 18th century law to send hundreds of Venezuelan migrants to a notorious prison in El Salvador. But even with this ruling, the legal battle is not over. CNN's Caitlin Polance is tracking this one, joining us right now. Tell us more about this ruling, what it means, what they said.
Kate, this is a lengthy ruling from a very important appeals court, and the question they're answering here is, are we in a war? And they say no, not in this context. The reason that this case is before this court, the Fifth Circuit Court of Appeals overseeing Texas and other southern states, is that the administration, the Trump administration, was trying to send Venezuelan migrants that they identified as being linked to the gang Tren de Aragua to El Salvador, to a prison, very swiftly. Those people went to court and said, wait a minute, they're using a law called the Alien Enemies Act that was passed many years ago and has only been used during the War of 1812 and the Great World Wars, World War I and World War II, to remove people without a lot of due process. That is not what this is, and Donald Trump is using that term improperly. The court ultimately agreed with much of that argument, saying that the Alien Enemies Act, Donald Trump is invoking it here to try and remove immigrants from American soil, but it can only be used when there's a declared war, an invasion, or a predatory incursion by a foreign nation. There's not a war here, and as far as the words invasion and predatory incursion go, that means there has to be some sort of military force. And what Tren de Aragua does on U.S. soil, even if there is alleged drug trafficking that they're participating in as a weapon of war, as the administration says it is, that is not going to amount to a wartime where the president can use this particular act. What Judge Leslie Southwick of the Fifth Circuit writes, we conclude that the findings do not support that an invasion or a predatory incursion has occurred. We therefore conclude that petitioners are likely to prove that the AEA, the Alien Enemies Act, was improperly invoked. This is a lot of legal, technical language looking at individual words in an act from many years ago, Kate, but it's really important because this is about the president's power to enforce his immigration policies. This was something that the Trump administration tried in the spring to remove immigrants, and now the question remains, how far can the administration go? This is going to likely ultimately be looked at by the U.S. Supreme Court, but this court, the Fifth Circuit, is not buying this argument from the Trump administration. Kate?
It is fascinating, and as you describe it, even when they get into technical details of various wars, this is what it looks like when you push the bounds of something or the bounds of something hasn't been tested. And that's what we're seeing play out. It's really fascinating. Caitlin, thank you so much.